10 U.S.C. Section 252, a modern federal statute, reads, use of militia and armed forces to enforce federal law. Whenever the president considers that unlawful obstructions, combinations of assemblages, or rebellion against the authority of the United States make it impracticable to enforce the laws of the United States in any state, by the ordinary course of judicial proceedings, he may call into federal service such of the militia of any state and use such of the armed forces, that's the full-time military, as he considers necessary to enforce those laws or to suppress the rebellion. Shipwrecked Crew then quotes again, obstructions, combinations of assemblages, or rebellion against the authority of the United States. He writes, that is quite a distance short of an insurrection against the federal government. What it recognizes is facts on the ground that state and local authorities are not capable of or are unwilling to maintain an environment in their communities where the federal government is able to enforce federal law. That is the extent of the justification required for the president to impose the conditions under which federal law can be enforced. It does not mean taking over policing via the military. All right, back to Shipwrecked Crew. The application of Insurrection Act sections 252 and 253 to these obstructionist states. He writes, the process begins after arrest. Steps or unlawful combinations taken in advance of arrest that interfere with those arrests are obstructing to execution of federal law. It is entirely appropriate for the federal government to arrest state and local officials involved in these efforts. Authorizing, approving, planning, assisting, etc. Passive resistance is not doing nothing. It is still resistance and therefore obstructive behavior. Presidents have expressly invoked the Insurrection Act statutes 30 times in the country's history. Remember, Trump's only president 47. So that means more than half, almost 3/4 of the presidents have invoked the Insurrection Act. Some were in response to general lawlessness of the population that was beyond the ability of state and local officials to contain. And he lists a bunch of examples here. This is great. I love this bulleted list. Examples of prior historical uses of the Insurrection Act. First, the earliest was the invocation of a prior version of what later became the Insurrection Act in response to the Whiskey Rebellion in 1791. By the way, the Insurrection Act is only, 1800, when is it? I looked it up before we started. 1807. When Congress passed the Insurrection Act, this was in recent memory, right? The lifetime. It was within 17 years of the Whiskey Rebellion of 1791. President George Washington marched 13,000 militia from Virginia, Maryland, New Jersey, and Pennsylvania into Western Pennsylvania. That would be the Appalachians. He marched 13,000 militia from Virginia, Maryland, New Jersey, and Pennsylvania into Western Pennsylvania to suppress a rebellion over the imposition of a federal tax on whiskey. That wasn't in opposition to the authority of the United States as a whole, as District Judge April Perry in Chicago idiotically claimed last week was necessary. I added the idiotically. Shipwreck Crew didn't say that. Second, President Jackson invoked it to quell the Nat Turner slave rebellion in 1831. Third, President Grant invoked it to suppress the Ku Klux Klan and enforced the Reconstruction Acts in the former Confederate states multiple times between 1871 and 1874. 4, President Cleveland sent federal troops to put down the Pullman Company strike by 4,000 railway workers in 1894. 5, President Eisenhower sent 1,000 active duty soldiers from the 101st Airborne in 1957 to enforce desegregation of Little Rock Central High School after the Arkansas governor used the Arkansas National Guard to keep 9 black students from attending. 6, President Kennedy in 1962 ordered various MP units of the 108th Cavalry Regiment and eventually a total of 13,000 military personnel to secure the campus of Ole Miss and suppress a violent protest by 2,500 people opposing desegregation of the school. 7. President Bush 41 used federalized National Guard in 1992 to suppress riots following the verdicts in the Rodney King case. But likely the biggest controversy over the possible invocation of the Insurrection Act is the fact that a president's decision to do so, and thus the presence of federally directed military forces in U.S. cities, has been determined by the Supreme Court to be almost entirely beyond the scope of judicial review. The foundational Supreme Court decision in Miller v. Mott, 1932, has already received much attention in the cases of Newsom v. Trump and Oregon v. Nome. These are two cases where Trump activated the state National Guards under Statute 12406, which I see here, Shipwreck Crew's about to get you. That's a different authority and a more conditional authority than the Insurrection Act. He writes here, but those cases involve the president's invocation of his authority under 10 U.S.C. Section 12406, not under the statutes of the Insurrection Act. Compare the following two passages in terms of the nature of discretion granted to the executive by Congress. And this is the point I made earlier. The President Trump is given much more unreviewable discretion under the Insurrection Act than he's given under 12406. For example, Section 12406(3), whenever the president is unable with the regular forces to execute the laws of the United States, the president may call into federal service members and units of the National Guard. Now, federal judge April Perry, a Biden appointee, only been a federal judge a couple of years, the one I called, not Shipwreck Crew, but I called an idiot. She's argued that this condition, president is unable to execute the laws, means that he is entirely unable. If he tries 1,000,000 times to enforce the law and he fails in all but one of those efforts, that means he's able to enforce the law. 1 out of 1,000,000 times is enough for April Perry to say, no, the president can clearly still enforce the law. He can fail 999,999 times out of 1,000,000. But according to federal judge April Perry, Biden appointee class of 2023, I believe, that means the president is able to enforce the law. And when it comes to the condition of using the regular forces to execute the law, if he's unable to enforce the law with the regular forces, she interprets that the same feckless, idiotic judge, April Perry, interprets that regular forces condition to mean not the regular federal authorities like ICE or DHS or Federal Protective Services or the U.S. Marshals or the FBI or the Capitol Police. No, in her mind, regular forces means the full-time professional U.S. military, the U.S. Army, the U.S. Navy, the U.S. Marine Corps, the U.S. Air Force, the Coast Guard, Space Force. In the mind of the feckless federal judge April Perry, Biden appointee, Trump would only be permitted under this statutory language to activate the National Guard if every member of the full-time U.S. military had first failed to subdue the insurrection. Then you can call out, no offense, guys, then Trump would be allowed to call out the weekend warriors. Does that make any sense? Forces that have nuclear weapons at their disposal, if they fail, then you can call out the National Guard. This kind of language in the United States, that's given these feckless judges wiggle room to obstruct President Trump with TROs. But now when we look at the Insurrection Act, we see it's a lot less conditional, isn't it? It's not when the president is unable. That's a judgment call with the regular forces. That's subject to interpretation. In Section 252 of the Insurrection Act, it says, when the president considers, he need merely consider. It doesn't have to be proven. It doesn't have to satisfy a federal judge. Congress wrote these words to authorize the president's federalization of a state National Guard whenever the president considers that unlawful obstructions, combinations, or assemblages or rebellion against the authority of the United States make it not unable, but impracticable to enforce the laws of the United States. And then Section 253 of the Insurrection Act, the president, by using the militia or the armed forces or both by any other means, shall take such measures as he considers necessary. There is no room for judicial review here. It's whenever the president considers and the measures he considers necessary. In that U.S. Supreme Court case of, so Shipwright calls it two different names. He called it Miller v. Mott earlier up here, Miller v. Mott of 1932. I don't think that's correct. I think his second reference is correct here. Martin v. Mott. In fact, you know what? Let me just check it. I believe it's Martin v. Mott. Yeah, Martin v. Mott, 1827. In Martin v. Mott, the Supreme Court held, quote, quoting the decision now, a free people are naturally jealous of the exercise of military power, and the power to call the militia into actual service is certainly felt to be one of no ordinary magnitude. But it is not a power which can be executed without a correspondent responsibility. It is, in its terms, a limited power. If it be a limited power, the question arises, by whom is the exigency to be judged of and decided? Is the president the sole and exclusive judge whether the exigency has arisen? Or is it to be considered as an open question? Everybody can have a controlling opinion. We, the Supreme Court, are all of opinion that the authority to decide whether the exigency has arisen belongs exclusively to the president, and that his decision is conclusive upon all other persons. We think that this construction necessarily results from the nature of the power itself and from the manifest object, purpose, contemplated by the act of Congress. Shipwreck Crew continues, the manifest object contemplated by the act of Congress is the obstruction of the execution of the laws of the United States. That is the avowed goal of elected officials such as mayors of Portland and Chicago and the governors of Oregon and Illinois. Every time Chicago Mayor Brandon Johnson or Illinois Governor J.B. Pritzker speaks out about protecting illegal aliens or opposing DHS ICE enforcement efforts, they only further make the case that they are obstructing the execution of federal laws requiring the deportation of illegal aliens. What I believe, Shipwreck Crew writes, what I believe the Trump administration has been doing since June when it launched its aggressive immigration enforcement efforts was to give these blue state governors and mayors the opportunity to establish the factual record that their purpose in managing the federal effort to immigration law is to frustrate its effectiveness. Had they cooperated or simply stayed out of the way, DHS and ICE would likely have been able to do their jobs, but their agitation of the public against the Trump administration's enforcement of existing law, combined with more than simple non-participation by state and local forces when large numbers of protesters showed up in an effort to frustrate immigration efforts, very likely results in the unlawful combination that is referred to in sections 252 and 253 of the Insurrection Act above. Great work, Shipwreck Crew. Check them out on Substack and, of course, on X. Represented 91 January 6th clients. I said over 100, so I was close. 91. 22 years as a federal prosecutor prior to that. Does really good work. I'm a big fan.